84-0 was the vote here in the Senate. The reason the PROTECT Act was put into place is the Senate was concerned over lenient sentences by judges in child porn cases, which is what you described. You said about it, there was an increasing perception on Capitol Hill and within DOJ that liberal judges were to blame for the downward pressure on federal sentences and that legislation was necessary to rein them in. That's you in 2011 describing this law. So Congress has set the guidelines here, 84-0 in the Senate. I noticed the chairman voted for it, as did a number of other members of this committee. So the Congress sets the range. Essentially, it's 97 months up to 10 years. Now, the prosecutor in this case, this is in D.C., of course, you're on the federal district court. The prosecutor in this case, it's a liberal administration, I think it's fair to say. This isn't the state of Texas. See my colleague from Texas next to me here. The prosecutor in this case, nevertheless, still asked for 2 full years in prison. You gave the defendant 3 months. Guidelines called for 10 years. Prosecutor wanted at least 2. You gave him 3 months. And when you did, you made a number of arguments and statements in the record, and I'd like to go through some of them because I've read them all. And the first argument you made was that the federal guidelines that punished child porn offenders, the ones that Congress wrote, were, and I'm quoting you now, are in many ways outdated. That's your quote. And you went on to say about why you thought they were outdated. I'm going to quote you again. You say, and I quote, "I don't feel that it's appropriate to increase the penalty on the basis of the number of images or prepubescent victims," meaning little kids, "as the guidelines require, because these circumstances exist in many cases, if not most, and don't signal an especially heinous or egregious child pornography offense," end quote. I just want to ask you about that because I just have to tell you I'm having a hard time wrapping my head around it. We're talking about 8-year-olds and 9-year-olds and 11-year-olds and 12-year-olds. He's got images of these, the government said added up to over 600 images, gobs of video footage of these children, but you say this does not signal a heinous or egregious child pornography offense. Help me understand that. What word would you use if it's not heinous or egregious? How would you describe it?
Thank you, Senator, for letting me address the concern that you've put forward based on the record that you've reviewed. As a judge who is a mom and has been tasked with the responsibility of actually reviewing the evidence that you would not describe in polite company, the evidence that you are pointing to, discussing, addressing in this context is evidence that I have seen in my role as a judge. And it is heinous, it is egregious. What a judge has to do is determine how to sentence defendants proportionately consistent with the elements that the statutes include, with the requirements that Congress has set forward. Unwarranted sentencing disparities is something that the Sentencing Commission has been focused on for a long time in regard to child pornography offenses. All of the offenses are horrible. All of the offenses are egregious. But the guidelines, as you pointed out, are being departed from even with respect to the government's recommendation. The government, in this case and in others, has asked for a sentence that is substantially less than the guideline penalty. And so what I was discussing was that phenomenon, that the guidelines in this area are not doing the work of differentiating defendants, as the government itself indicated in this very case. And so that's what I was talking about, but I want to assure you, Senator, that I take these cases very seriously, that these cases include the notion by many defendants that the folks at issue, the defendants themselves, are collecting these images on the internet. They're terrible things that have happened, but they're not involved, say the defendants. They're not focused on, what is actually happening to the children. And so part of my sentencings was about redirecting the defendant's attention. It's not just about how much time a person spends in prison. It's about understanding the harm of this behavior. It's about all of the other kinds of restraints that sex offenders are ordered rightly to live under at the end of the day. The sentences in these cases include not only prison time, but restraints on computer use, sometimes for decades, restraints on ability to go near children, sometimes for decades. All of these things judges consider in order to affect what Congress has required, which is a sentence that is sufficient but not greater than necessary
Let me
to
just ask you-
promote the purposes of punishment.